Today's hearing will examine the effectiveness of the bankruptcy system and help determine if narrowly tailored legislative updates are warranted to ensure that the bankruptcy system continues to work as intended. The bankruptcy system in this country is designed to provide debtors with a fresh start. Entrepreneurs and small businesses are the lifeblood of the economy, and the calculated risks they take are responsible for so much of the innovation in this country. These risks are often funded by debt, and while many entrepreneurs and small businesses succeed, some of them fail. Instead of being perpetually saddled with the unsustainable levels of debt, the bankruptcy system allows debtors to enter bankruptcy, reorganize their debts, maybe discharge some of it, and exit bankruptcy in a position to continue to innovate and take additional risks. The same is true for consumers. Some consumers get themselves in an unsustainable financial position, and the bankruptcy system throws them a lifeline. But while bankruptcy can greatly benefit debtors, creditors are also entitled to repayment. Therefore, the bankruptcy system must strike a balance between preserving the rights of creditors to receive repayment and the opportunity for debtors to start fresh. We have proposals before this committee that will change how the bankruptcy system works in the future, and nearly 30 temporary bankruptcy judgeships will begin expiring in 2026. And while judges will not be kicked out of their seats, certainly, new judges cannot be appointed when a judge's term expires. We must determine whether those judgeships remain necessary, and we will hear testimony from 2 sitting bankruptcy judges to help inform our decision. Also, the pay per case for Chapter 7 trustees has not been increased in over 30 years. Chapter 7 trustees play a critical role in our bankruptcy system, liquidating a debtor's assets, dispersing funds to creditors, and ensuring that the only eligible debtors enter Chapter 7 bankruptcy. We also must determine whether to increase the debt limit for Subchapter 5 cases. In 2020, shortly after enactment, Congress increased the debt limit for Subchapter 5 cases to $7.5 million. Last July, this increased debt limit expired and reverted to around $3 million. We must determine whether we should allow that number to remain or whether the cap should again be raised, either temporarily or permanently, to ensure small businesses can continue to seek their avenue for reorganization. We must also figure out what, if anything, we should do about student loans in bankruptcy. And under the Biden-Harris administrations, there were thousands of student loans that were forgiven by largely waiving the bankruptcy code's undue hardship requirement. As a result, we saw the number of student loans discharged in bankruptcy increased by 330%. While the cost of education has skyrocketed, something the subcommittee has already begun to examine, American taxpayers should not be on the hook for someone who took out loans to get a potentially useless undergraduate degree from a private university and now cannot pay it back. Finally, we will examine whether our bankruptcy laws as written can sufficiently capture the treatment of genetic information in bankruptcy proceedings. We should have robust debates and, if proven necessary, enact narrowly tailored changes to the bankruptcy code to make sure that the system works better for small businesses, consumers, and creditors alike. I want to thank Ranking Member of the Subcommittee, Mr. Nadler, for agreeing to hold a bipartisan hearing today. I think that working together on bankruptcy reform will greatly benefit the American people. I also want to thank the witnesses for appearing here today. We have assembled a large panel of bankruptcy experts who are well equipped to answer all our questions, and I look forward to hearing what each of them has to say today.